Good morning. This is Michael Buckner with the Michael Buckner Law Firm. Well, thank you for joining us this morning. We will begin in approximately 1 minute. Good afternoon to those on the East Coast, and good morning to those on the West Coast and in between. Welcome to the Michael L. Buckner Law Firm webinar, Investigation Strategies for the New NCAA Enforcement Process. My name is Michael Buckner, an attorney with the Buckner Law Firm. I will be your presenter for today's webinar. We are joined today by representatives of over 75 universities, conferences, and other parties. Welcome and thank you for joining us this morning. You should have received via email 5 documents yesterday. A copy of the PowerPoint slides that we will refer to during today's session, the August 2013 version of the NCAA Enforcement Investigations Toolkit, which was prepared by the Buckner Law Firm, the webinar handout, the evaluation form, which we ask you to complete at the conclusion of today's session, and thereafter email, fax, or mail to us. And finally, a newsletter registration form, which you can use to sign up to receive our law firm's complimentary newsletters and other resources. Before we begin, I want to review some housekeeping items with you. First, your phone line will be muted during the webinar. If you would like to ask a question, please use the Ask the Question feature, which is located on the upper left-hand corner of your screen, to send me a question. At the conclusion of the presentation, I will answer as many questions as time permits. If I cannot get to your question during today's session, I will send you responses to all the submitted questions within 2 weeks. Second, we have a lot of ground to cover during the next hour. So today's presentation will be a brief overview of the new process and strategies you can use during an enforcement case. The toolkit contains a detailed summary of the new enforcement process. So I refer you to look at those materials. However, the Buckner Law Firm is available to conduct complimentary workshops via telephone or on your campus if you would like more information on the new process. Members of the Buckner Law Firm are also available to answer questions via email. You can find all of our information, including our contact information, in the webinar materials. Third, this event will be recorded, and your participation in this call constitutes your consent to be recorded. Finally, if you cannot see the PowerPoint slides through the meeting burner system, please refer to the copy of the slides that were emailed to you yesterday. Now, let's begin. The webinar is going to cover 3 main issues. One, we're going to highlight the major elements of the new enforcement process. Secondly, we're going to discuss 11 strategies that you can use if you're in the enforcement process or you're contemplating how to improve your compliance program or your investigation plan. We're going to talk about those strategies. And finally, throughout today's discussion, we're going to talk about proactive measures that you can use to better align your institution's policies, procedures, so that if you do get into the major enforcement process, you're better prepared to deal with the procedures of the new process, including some of the tactics that the enforcement staff will use in this new process. Let's go through. This first part is going to be a brief overview and summary of the major elements of the new process. We won't have time to go into great detail about every single aspect of the process, but I just want to go over it with you. Again, I refer you to the toolkit, which you should have received yesterday in your webinar materials. That contains a very good summary of the entire process. Essentially, the new process has created a 4-tier structure. As we all know, prior to August 1st, 2013, it was major and secondary violations. The new process now is a 4-tier structure. We have 4 levels of violations, which are now called breaches of conduct. So the breaches of conduct, the highest levels of breaches of conduct, levels 1 and 2, are supposed to respond to those violations that undermine or threaten the NCAA Constitution and bylaws. The highest level, or the most serious breach of conduct under the new system is called a level 1. It is a severe breach of conduct. And the least significant, or the most minor breach of conduct, is called a level 4, or incidental. And we'll go into greater detail about each of those 4 levels in a few minutes. What the new structure also does is increases the size of the Committee on Infractions, the Division I Committee on Infractions, from 10 to 24 members. Some of those new members are going to be to reflect greater diversity of the membership. You're going to have presidents, former coaches, and compliance administrators on the panel. On the full Committee on Infractions. You'll still have a committee chair and a committee vice chair, but what's a new wrinkle to this process is each case will not be heard by the Committee on Infractions. It will be heard by a hearing panel, and those hearing panels will be composed of 5 to 7 members of the full committee. And the Committee on Infractions chair will select a chief hearing officer for each hearing panel. So that's going to be a unique twist to that. Now, the new process has not changed the appellate structure. So the Infraction Appeals Committee will still be comprised of 5 members. One of the aspects of the process which they're emphasizing, and the working group that developed the process emphasized, and you'll hear me talk about throughout today's webinar, is accountability and shared responsibility. And they've actually included a new bylaw, Bylaw 1901-2, concerning accountability. And they want to make sure that everyone involved in athletics on an institution's campus understands that they're going to be held accountable both on an individual basis and on an institutional basis. And later on, we're going to talk about the revised Bylaw 11-121, which is head coach control. But under the new process, head coaches are going to come under more scrutiny. They're going to be presumed to be responsible for their program, to promote atmospheric compliance, and to monitor their program. We'll talk about a little bit about that more in various aspects of today's presentation. But most importantly, head coaches need to understand, as many of you are aware, that even under a level 3, which under the old system would be a level 1 secondary violation, head coaches are even susceptible to be punished by partial suspensions for part of the year or for a full season. In our handout, the webinar handout, we have a list that was prepared by the NCAA enforcement staff, a list of the level 3 violations that head coaches could be suspended for. What the working group was trying to do was they're trying to align the penalties with the type of the seriousness of the violation. And we have, again, in our handout, in the appendix to the webinar handout, the penalty matrix, which will be used by the hearing panels in level 1 and level 2 cases to determine what ranges of penalties can be imposed in a certain case. And so as you'll look at the penalty matrix, the most serious level 1 cases, which are going to be called level 1 aggravation cases, that means those cases have aggravating factors in them, are going to be susceptible or eligible for the most serious ranges of penalties on that penalty matrix chart. And you're going to hear me talk a lot about aggravation and mitigation a lot today. If you take anything away from this webinar, it's that this new process has borrowed elements from the federal sentencing guidelines. For those attorneys on this call, you will understand what that means. For the non-attorneys, that means that there's going to be a lot of analysis by the enforcement staff and by the hearing panels as to, are there any factors that aggravate the violation, or are there any factors that minimize or mitigate the violation? And that will weigh heavy on the type of penalties or range of penalties that the hearing panels can impose in a given case. So we're going to talk about that throughout all the strategies. One thing that the new process will continue from the old system is the concept of shared responsibility, and that ties into the accountability bylaw that I went over earlier. Again, all members of the institution's campus and those who have athletically related duties and responsibilities are expected to share responsibility to ensure rules compliance, and that will not change under the new system. Now let's go through briefly the 4 levels, the 4 violation levels under the new process. Level 1 under Bylaw 1911 is severe breach of conduct. Those breaches of conduct are those that seriously undermine or threaten the integrity of the NCAA Constitution and bylaws, breaches of conduct that provide or are intended to provide a substantial or extensive recruiting, competitive, or other advantage, or provides or is intended to provide a substantial or extensive impermissible benefit. Also, multiple or collective Level 2 and or Level 3 violations can also constitute a Level 1 case. And we'll talk about in one of the strategy slides about upgrading of a Level 3 and a Level 2 case. And we'll talk about some of the strategies that you can use to develop arguments to keep cases at the level that you think they should, and versus the enforcement staff or the hearing panel may disagree. And we'll talk about at various stages what you can do to populate the record with enough information to make your arguments sound. A type, for example, Level 1 case could range from lack of institutional control, serious academic fraud cases, cases in which involve tremendous amounts of extra benefits involving large numbers of student athletes or programs over a significant period of time. Level 2 cases under Bylaw 1912 is significant breach of conduct. Those breaches are provide or intended to provide more than a minimal recruiting, competitive, or other advantage, more than a minimal impermissible benefit, or compromises the integrity of the NCAA rules, or collective Level 3 violations. Again, we will talk about upgrading Level 3 cases to a Level 2 or a Level 1 later on in today's presentation. Level 3 are breaches of conduct under Bylaw 1913. Those violations are isolated or limited in nature, provides no more than a minimal recruiting, competitive, or other advantage, and does not include more than a minimal impermissible benefit. Also, multiple or repeated Level 4 violations can be considered Level 3 type case. Level 3 violations are roughly akin to, under the old system, a Level 1 secondary. Level 3 violations will be processed, again, as under the old system, by the secondary enforcement staff. What we included in the handout, in the appendix to the webinar handout, are the Level 3 violations that a head coach could be suspended for or receive sanctions for. So I want you to refer to that. And finally, Level 4, incidental infraction under Bylaw 1914. Those are inadvertent and isolated, technical in nature, and have very little competitive advantage. These are going to be the technical paperwork violations, and these Level 4 violations are going to be processed at the conference level. Essentially, Level 4 violations do not affect eligibility generally, and we have included in the webinar handout, in the appendix to the handout, a document prepared by the enforcement staff. The enforcement staff has listed what they believe to be Level 4 violations, which again can be processed, which will be processed through the conference office. The penalty metrics. We have in the appendix to the webinar handout the complete penalty matrix, which will be relied upon and used by the hearing panel to determine the penalties that can be imposed in a Level 1 or Level 2 case. The matrix is designed to impose serious sanctions for the most serious violations, but also impose less serious sanctions for cases in which violations are not as serious. And so if you look at the penalty matrix again, you'll see the most serious ranges of penalties are for the level 1 aggravation cases, and the less serious penalties will be those implemented for the level 2 mitigation cases. Now, one of the tricks is in the bylaws, the committee still has an out, so they can still go outside the ranges if there are certain circumstances present. The bylaws, of course, do not specify what those circumstances are, and so it's going to take a few years with case precedent, and those of you on the call to develop the necessary case precedent to fully define and flesh out what those circumstances are going to be. The matrix was developed based upon a membership survey in which the membership supposedly indicated that postseason bans and significant scholarship reductions would be the most effective to address major or now level 1 and level 2 rules violations. One of my colleagues, Justin Seifert, applied a most recent case, which is the Oregon case from this year, and applied the new penalty matrix to the facts of the Oregon case. The results of his analysis were posted to the law firm's blog, and on the slide you'll have the web address to that blog post. I highly encourage you to look at that, and that's just our initial stab at what a case would look like if it was processed under the new system and the new penalty matrix. I mentioned earlier that Bylaw 11121 was revised for head coach control. Under the new bylaw, new revised bylaw, head coaches are presumed to be responsible for the actions of everyone who reports to him, directly or indirectly. That includes coaches, staff members, and student athletes. Head coaches are still, under the bylaw, required to promote an atmosphere of compliance within their program and to monitor the activities of coaches and administrators. The difference is, under the old bylaw, the old 11121, the bylaw operated on knowledge, actual perceived knowledge of the head coach. The revised bylaw is based upon a presumption of knowledge. So if there's a level 3 or level 1, level 2 violation in a program, the hearing panel and the enforcement staff will presume that the head coach had responsibility. And so therefore, the head coach will be responsible. And that's why you now will have head coaches could receive suspensions for even level 3 violations under the new system. The head coach can fight that presumption under the new bylaw by demonstrating that they promoted an atmosphere of compliance and that they monitored their staff and everyone involved in their program. For those of you who are in compliance, there are resources on the NCAA website that discuss some strategies that you can share with your head coaches in terms of making sure that they are communicating their expectations of rules compliance to their program and are doing all the necessary things that they need to do to document that they have control of their program. It's also incumbent upon the institution to ensure and to provide the necessary resources and policies and procedures to assist the head coaches with head coach control. The more the head coach controls the program and minimizes violations, the less likelihood that there will be level 1 and level 2 violations on a campus. Or if there are level 1, level 2, you can show through documentation that the head coach and institution monitored, and that can be used as a mitigating factor. Bylaw 19812 is a new bylaw to the enforcement process. Under the old system, when the Committee on Infractions will release a public infractions report, individuals were identified by titles or affiliations. So it would be, instead of saying someone's actual proper name, they would give their title, or if it's a booster, they would talk about representative of an institution's athletics interests. Under Bylaw 19812, the hearing panel will have the discretion to identify by first and last name the individuals listed on the slide in front of you. So for a lack of institutional control cases, the hearing panel will have the discretion to name the president or chancellor in a case. For lack of control or failure to monitor cases, the AD. For lack of control or failure to monitor cases, the person to whom athletics reports to. At some schools, it doesn't report to the president. So whoever athletics reports to, that person could be named in a infraction report. The head coach can be named now, and as well as the chair or members of your board of regents or trustees could be named in an infraction report if the hearing panel feels it is necessary to identify them in the report publicly. Again, this goes back to what we talked about earlier about accountability and shared responsibility. The implementation, these next two slides talk about the implementation of the new system. For any breaches that occurred before October 30th of last year, but processed before August 1st, the current process were the old process and penalties. Breaches that occurred before October 30th were processed after August 1st, the new process, and they will compare which penalty matrix would be more lenient, the old system or the new system. From this point forward, most of the violations that are going to be processed by the staff or the hearing panels will be cases under this slide. Breaches that occurred before and after October 30th of last year and processed after August 1st, 2013 will be the new process and the new penalty matrix if most of the violations occurred after October. And then, of course, any breaches that occurred after October 30th of 2012 and processed after August 1st will be the new process and new penalty matrix. Now, the second phase of our program is going to go into strategies. We have divided this section into 11 strategies, starting with investigation policy all the way through the actual post-hearing submissions. So hopefully you can take one or more of these strategies that you can use in your own program or your own institution before an investigation starts, during, and after an investigation. Strategy number one discusses the investigation policy. Having a written investigation policy is very important for numerous reasons. One, under Bylaw 1994, certain benefits of having a well-run investigation could be seen and can be argued as mitigating factors. So the fact that a school self-reported violations or had exemplary conduct during the investigation can be used and can be cited as mitigating factors. So it's important that the institution develops sound investigation policies to guide how it takes in allegations, how it processes it, and how it conducts an investigation to determine whether or not the allegations are true or not. So your investigation policy should contain or address the following issues. When you receive an allegation, you need to verify it. We receive all the time, clients receive all the time, you receive all the time, rumors and innuendos and gossip about possible rules violations. Those rumors, gossip, and innuendo do not necessarily mean that all those need to have a full-blown investigation. So you need to do due diligence to determine which allegations are of a substantial nature that requires further investigation, either at the level 4, 3, 2, or 1 case. So you need to interview the person who brought the allegation, if that person is available. Conduct some due diligence research on the internet or some fact-finding. And if you determine that the allegation is just unsubstantiated, it's just innuendo, it's nothing to be worried about, then you document your methodology. What did you do to do your due diligence, and place it in the file? Because if the NCAA comes back later and says, hey, institution, did you receive this allegation? What were your thoughts about it? You can be able to pull out your file and say, we received the allegation, and these are the steps that we did to make sure that the allegation is substantial or not. We made a determination based upon our methodology that it wasn't of a substantial nature, and we closed the file. If your due diligence concludes that it is of a substantial nature, then we advise you to begin the actual formal investigation process under either of the 4 levels. And if it's of a really substantial nature, what I mean is of a level 1 or level 2, possible level 1 or level 2, we advise you to contact the NCAA, to let them know about that. Why? Because they could also have received the same allegation from the same or similar source. They could start their own investigation. You will want to be able to know what the NCAA wants at the earlier stage and not be surprised later on. So you can conduct a joint investigation. You can advise the enforcer staff that you're conducting your own internal investigation, and making sure that you are cooperating with the enforcer staff, which you're required to do. Cooperation does not mean that you give away all your defenses. At the end of the day, your job is to protect the interests of the institution. And if you feel that the enforcer staff is overstepping their bounds, they're not following their own procedures, or they're incorrect on their analysis, then it's your job as the investigator or as someone who's working at the institution to provide the hearing panels with the most accurate information so that they can determine whether or not a rules violation occurred or a breach of conduct occurred. Also, if the allegation involves any type of possible criminal matter, we advise you to immediately reach out to federal or local law enforcement. We had one of our clients had a case in which an assistant coach was alleged to have committed or had placed illicit wagers at a local sports book that was using a local body shop as a front. Well, we immediately contacted local law enforcement to conduct to coordinate our investigation. Those type of situations, you don't want to wait until later on. You want to definitely involve federal and local law enforcement. Your investigation policy also needs to address how are your allegations handled. If it's a level 1 and 2 case, do you retain outside counsel? Do you have the general counsel conduct the investigation? Do you have an investigation team? If it's a level 3, do you have the compliance office conduct the investigation? What happens if a level 3 case is upgraded to a level 1 or level 2? Does your investigation policy address that? If you have a level 3, if you think it's a level 3, and the compliance office is in charge of handling all level 3 investigations, and the enforcement staff comes and says, the institution, we think this needs to be upgraded to a level 2 case. Does your investigation policy dictate that it stays with, the compliance office continues its investigation, or do you immediately retain outside counsel or have the general counsel or the FAR or an investigative panel take over that investigation? These are questions that you need to ask yourself as you go back and look at your investigation policy. Also, your investigation policy should address if the investigator that the policy says is supposed to handle the case, if there is a potential conflict with that investigator, the policy should be flexible enough to be able to have an alternative to select the investigator. Let me give you an example. If your investigation policy says that all level 1 and level 2 violations are to be investigated by the faculty athletic representative, and the FAR is intimately involved in the eligibility certification process, including being a signatory on a lot of the documentations and reviewing the information. And if the institution receives an allegation that there are eligibility violations involving the certification process, then it's not a good idea to have the FAR head up the investigation. So your policy needs to have an alternative means to selecting that person to head that investigation. And then your policy needs to address if the institution does not receive the allegation, but the enforcement staff does receive the allegation, they do their due diligence, and based upon their preliminary investigation, they determine that a notice of inquiry under Bylaw 1953 is appropriate, and they contact the institution either orally or in writing, indicating that they're going to conduct a formal investigation. Your plan should address that. That if the allegation comes from the NCAA, how are you going to handle that? Who's going to handle that investigation? You're going to hire, again, outside counsel and have the general counsel do it, or you're going to have the compliance office handle that investigation? Strategy number 2 covers compliance programs. And this is one of the proactive measures that we mentioned earlier that we're going to talk about. You should start thinking now about how can you as the institution revise your practices, policies, protocols, and procedures to be in the best position if an allegation occurs, especially from a level 1 or 2 nature. And we'll talk about some strategies in this section. First, you need to focus your compliance program. You need to thoroughly review Bylaw 19. And your compliance program should focus on certain core areas, making sure, one, that your head coach is well aware of his or her responsibilities under revised bylaw 11.121, that they're promoting the atmosphere of compliance, that they're monitoring their staff, and able to provide and assist the head coaches with doing that. Again, I refer you to the NCAA staff has developed pretty good resources and materials on some possible strategies that you can use and share with your head coaches on this topic. Also, again, we talked about accountability and shared responsibility. The hearing panels will be looking at is compliance, institutional control, and a sense of responsibility for rules compliance. Is that shared from the top of the organization all the way down, from the board of trustees all the way down to the student athletes? So you want to be able to document that, in terms of rules of education, policy procedures, board of trustees or regents policies dealing with athletics. Begin thinking about if you received a level 1, level 2 case right now, how can you prove that you have mitigating factors? How can you prove that you have, under the new bylaws, have the sufficient elements to maintain an appropriate compliance program? You want to be able to make sure that you've also conducted an audit for at least every 4 years. More institutions now are going to audits on a more frequent basis to make sure that they have the most accurate information and most current information concerning the status of their compliance programs. We also advise that compliance staff track the major cases. And now that we're in the new system, a lot of the case precedent, it no longer applies as to what is a major case, what is a secondary case, and some of the procedural aspects. So it's going to be very important for us as a law firm and for you as member institutions to keep track of what are some of the new decisions from these hearing panels. How are the hearing panels defining institutional control as a level 1 case? What are they considering to be, what type of violations or categories of violations are they considering to be level 1s or level 2s? How are they going to treat multiple level 3 cases and that are possibly upgraded to level 2 or level 3? How are they applying the penalty matrix to different types of cases and the severity of cases? Those are things in which you need to be tracking, because that will give you some helpful hints as to what and how to concentrate your compliance resources to make sure that your compliance program is highlighting the elements and the most important issues that are defined by the hearing panels. Also, your compliance program needs to look at the aggravating factors under bylaws 19921 and 1993, and the mitigating factors under bylaws 19923 and 1994. And you look at your compliance program and look at those aggravating factors. Are there any aggravating factors on that list, or any factors that you think could be considered aggravating that currently exist on your campus? And if so, what are strategies that you can put in place right now and document that to make sure that you reduce the likelihood or the occurrence or existence of those aggravating factors? And then, conversely, look at the mitigating factors list. Do those current factors exist on your campus? If they do, document it. If they do not, what strategies can you use? What type of resources can you devote to make sure that you promote those mitigating factors and document that? One of the mitigating factors is the history of reporting violations. So you want to make sure that you are cultivating an atmosphere of compliance where people are self-reporting and you're reporting to the enforcement staff level 3 violations. According to my conversations with the secondary staff and our own surveys, under the old system, if you report between 7 and 15 on average per year, that is not a red flag to the enforcement staff or to the Committee on Infractions in terms of a history of reporting. A lot of institutions report more than 15. So you need to look at, are we reporting between at least 7 to 15 level 3, level 4 violations each year? And if you are, then you're on pretty good track to have a history of reporting violations that you can use as a mitigating factor. Strategy number 3 is investigation plans. And both strategy number 3 and 4 deal with investigation plans. And what a plan is and this is what we do. When we receive an investigation, before we start any investigative activity, we plan out how are we going to conduct the investigation. What evidence are we going to collect? Who are we going to interview? What's the scope of the inquiry? Are we going to use experts? What type of research are we going to conduct or need to conduct in the case? All that is mapped out. So in these next two strategies, we want to talk about two important aspects of an investigation using a plan to help advance the institution's interests during an enforcement case. The first one is incorporating mitigation and aggravation factors into your investigation plan. Make sure that some of the essential elements of a plan, as I mentioned, the scope of the inquiry, who is the investigator, how you're going to collect evidence, you're going to reach out to experts, is well thought out. One of the benefits of a thorough and comprehensive investigation is it can be seen as a mitigating factor. Now, just cooperating with the process, just self-reporting information is your obligation under the bylaws. But if you have exemplary conduct, meaning is there something that the institution discovered or produced during the investigation that the enforcement staff would not have been able to find? That's exemplary conduct, for example. That can be seen as a mitigating factor. So you want to make sure that you have your plan well thought out so you can uncover information so that you can demonstrate to the hearing panel that we went above and beyond our duty under the bylaws and we assisted the enforcement staff. Now, the bylaws have made clear an institution can still promote or advance its interests and actually disagree with the enforcement staff and still claim mitigating factors, still claim that the institution had exemplary conduct, still went above and beyond, even if you disagree with the enforcement staff. So again, don't be afraid to advance your school's interests in this new process. Well, one of the things, the reason why mitigation and aggravating factors are important, as I mentioned earlier, is that the existence or lack of mitigation and aggravation factors will be directly used by the hearing panels to determine penalties and the severity of penalties in this case. So when you're developing your plan, you want to make sure that through your evidence collection, your documents, your research, when you conduct interviews, that you're collecting evidence that will document the existence of mitigating factors, and that if aggravating factors are present, that you place those aggravating factors in the proper context. For example, if there was a violation, a serious level 1 violation, academic fraud, you want to make sure through your investigation that you ask the questions or get the information so that you can tell the hearing panel, yes, we have a very serious level 1 violation, but we had the necessary policies and procedures in place, we had the technology in place, we educated the faculty, we educated the student athletes, the coaches, the administrators involved, and we just had a rogue employee that committed the violation. Or we had a rogue group of student athletes that actually committed the violation. And so it's not necessarily will be successful at all times, but at least you're giving the institution some arguments that can be made at hearing in terms of mitigating factors or placing the aggravating factor in the proper context. Now, one thing I didn't mention is there is such a thing as a standard case. And a standard case is the middle row case. It's not aggravating, it's not mitigating. That the mitigation and aggravating factors are roughly equal. So those are going to have the middle range of penalties. So essentially, you really want to be successful in this process, you want to try to develop evidence, if it is there, that you can show that the case is either a standard case or it is a mitigation case. Now, sometimes, unfortunately, there won't be sufficient evidence to where you will be successful at arguing either a standard or mitigation case, but you have to think at the very beginning of your investigation plan, to develop that if it does exist out there and make sure it's part of the record. I mentioned earlier about extenuating circumstances. Those are situations in which the hearing panel can depart from the core penalties, either aggravation, standard, or mitigation, or from a level 1 type penalties or level 2 type penalties. You want to make sure that, again, you need to think about when you receive the allegation, you're developing your investigation plan, what are some possible extenuating circumstances that exist on your campus that you can document, and you document that through the investigation. Again, I mentioned exemplary conduct. That's a mitigating factor, but a failure to cooperate, if your institution does not cooperate or the enforcement staff alleges that you're not cooperating, that can be seen by the enforcement staff and the hearing panel as an aggravating factor. Strategy number 4, again, is the second part of the investigation plan. That's a case upgrade. That's when we talked about that a level 3 case can be upgraded to a level 1 or level 2 case, and a level 2 case can be upgraded to a level 1 case. Well, what do? Well, in our webinar handout, we have a checklist that you can use to ask yourself questions at the beginning of a case. And we advise that you do a lot of this at the beginning of the case. If the information is there, you need to analyze the allegations, the bylaws involved, if there's available case precedent. Is it possible that this case could be upgraded by the enforcement staff or considered by the hearing panel to be upgraded up from a level 2 case up to level 1, or if it's a level 3 case up to a level 1 or level 2? What you need to do then is you need to look at what are the available facts, having conversations with the enforcement staff, what they're thinking. Are they thinking about upgrading the case? And making sure that the record contains enough facts that you can make an argument as to why the case should remain at the level that you believe it should remain, or be downgraded to a level in which you believe it's appropriate for that particular case. Let me give you an example that my firm had recently. We had a client where we got into the case. The enforcement staff wanted to allege our client would have committed would be a level 1 type violation. And so through our investigation, we realized that was the staff's position. We developed enough information in the record through interviews and through evidence collection that when it came time down toward the end of the case to make that analysis, we were successful in convincing the enforcement staff that the case should not be what would now be a level 1 case. We were able to argue to the enforcement staff that the case should be what would now be considered to be a level 2 case. And because we were able to, at the beginning, when we prepared the investigation plan, we were able to tailor our activities to make sure that the record was sufficient with that information to base our arguments on. Again, this slide in front of you again talks about a level 2 case, and in terms of making sure that you tailor your investigation plan to collect the necessary evidence to argue if you want to maintain the case at the level that you believe is appropriate. Strategy number 5 is document information collection. That's one of the core activities of an investigation, collecting documents and information. Well, again, you want to suspend your document destruction policy. Your institution may have your software, your servers, your computer systems may automatically delete emails or other information. You want to suspend that because you may be destroying unintentionally evidence that might demonstrate that you have mitigating factors in place. So you want to do that. You want to be able to assign one person that will collect documents. You want to maintain a chain of custody, which means that you're monitoring, that you're documenting where the documents go, how they're maintained, to make sure that any involved individual or the enforcement staff cannot argue that you altered the documents in any way. And that argument has been made in the enforcement process. You want to, when you're collecting documents, again, seek mitigation evidence if it's there. And if you believe that there are aggravating factors present, what are evidence that you can collect to place those aggravating factors in the proper context? And you will make sure that if it's involves a sports program and there's a possible level 1 or level 2 out of a sports program, you will make sure you have documentation that the head coach promote an atmosphere of compliance and monitor his or her program. If you have core documents that you know that are going to be key to your case, they're going to be key at the committee or infractions hearing panel hearing, you want to make sure that those documents are genuine. You want to authenticate those documents. We had a recent case where another party had submitted a document, and the committee on infractions told the party that they were not going to consider that document because they didn't believe the document was genuine. So you want to make sure that you maintain a chain of custody, that you can demonstrate the document wasn't altered. And secondly, if you need to conduct an interview or collect other information to document to demonstrate that that document is the authentic document, that's what you need to do during your investigation. You need to collect information from all sources: electronic, social media, conducting investigative field activities. All those can be used to collect evidence during an investigation. Strategy number 6 is interviews. And interviews are, again, another important aspect of investigation. Again, you want to make sure when you're preparing your interviews and you're asking questions, that you're asking questions in part during your interview to collect mitigation testimony and aggravation testimony. Again, you're going to use that later on in your responses to notice of allegations and during the hearings, before the hearing panels. Before you start your interview or during your interview at the beginning, you want to make sure that you disclose to your interview subjects the necessary bylaws in 19 and 10, including the purpose of the interview, that they're required to provide truthful information, and that they're subject to the NCAA ethical conduct legislation. In your handouts, and specifically in the toolkit, we provided a version of what we use. We provide interview subjects a written statement that provides a notice of all their obligations on the NCAA legislation, and we also have a script where we go on the record and tell them again orally. That's again to make sure that they understand all their obligations. Make sure at the end of the interview that you follow up on all the issues that are disclosed in the interview, including if they identify other people in the interview, if they describe documents that you can collect, or they identify other issues that you need to follow up on. That needs to be done immediately after the interview. Strategy number 7 is self-reports. In the last few years, there's been a decrease in the number of self-reports we've heard that have been submitted to the enforcement staff. Institutions have really just allowed the enforcement staff to write notices of allegations. We feel that preparing and submitting self-reports is going to be very important in this new process, because this will be the first formal time that you will be able to argue and educate the enforcement staff about the level of cases you believe is appropriate and whether or not there are aggravating and mitigating factors present, or whether or not the case is a standard case. Let's talk about some of the strategies involved in preparing a self-report. The enforcement staff will provide you with access to their web custodial. They're going to use new technology now. They're going to use a system called the Box, which is a online platform, and it will enable you to access their investigation file as long as you have access to a computer and internet access. When you're preparing your self-reports and you have access to the web custodial, be sure you review all of the NCAA enforcement staff's files as well as your information. Check to see whether or not the enforcement staff has collected sufficient information to warrant a notice of allegations. If your investigation determines that there are no violations that occurred, then that's what your self-report should argue and base it upon. You need to analyze all evidence, including determine the motives and credibility of everyone that you talk to. Again, the toolkit has a checklist in which you can use to determine the credibility and motive of your interviewees, and also resolve any legal or regulatory issues. If there are any type of, based upon your investigation, you feel the need to terminate or implement some type of employment action against an employee, you will make sure that you've covered your bases with the General Counsel's Office and your Human Resources Department to make sure that you're following all of your necessary institutional rules. Again, make sure that your self-report contains certain minimal elements. including a description of what you believe the violation level should be, whether it should be a level 1, 2, or 3. If there are mitigation factors, you want to note that. If there are aggravation factors, you want to note that. But also, if your investigation has uncovered things in which to place the aggravation factors in a proper context, do you want to include that in the self-report? And if you believe that the violations, this case is a standard case, you want to be able to state that and argue it and support that with evidence that you develop through your investigation. Again, this slide contains the other elements of a comprehensive self-report. Strategy number 8 is the enforcement staff submissions. There are 3 core documents that are now part of the new process. And we're going to go through the 3 core documents and what you need to look for when you receive these documents. The first document is the Notice of Allegations. Under the new process, the Notice of Allegations has changed. There's going to be some additional information in the notice. The notice is going to contain the overall level of the case. Now, what that means is the enforcement staff will assign an overall level to the entire case and then assign a level to each violation in the case. So you can have several level 2s. In fact, you can have an entire case with level 2s. But if the staff believes that the collective nature of the level 2s warrants a level 1 case, then each individual violation will be a level 2, and then they will assign a level 1 case to the overall case. So the hearing panel will then consider the case as a level 1, and the institution will be possibly, be guided, or the hearing panel will be guided under the penalty matrix for the penalties under the level 1 categories. The notice also will list the specific evidence that the staff relied upon to develop the allegations. This is new to the notice. So the staff will have the evidence, a summary of the evidence, and they'll have a section on aggravating and mitigating factors and the evidence that support those aggravating and mitigating factors. And again, the staff will provide access to the institution involved individuals to the box, which is its document sharing platform, which will contain its investigation file. What you need to look at when you receive the Notice of Allegations is what are the weaknesses in the enforcement staff's evidence? Did the enforcement staff violate any procedure? Did they violate any bylaws? And you wanted to take a look at the notice and try to anticipate, if you were on the hearing panel, what would be your initial reaction to this notice? And you need to collect all that analysis, all that evaluation, and begin to prepare for not only the response to those allegations, but the hearing. So this is when we would develop a supplemental investigation plan. Do you need to conduct more interviews? Do you need to collect more documents? Do you need to do more research or more analysis of the evidence in order to shore up some of the weakness that you have identified or some of the issues that you identified through your analysis of the notice? Now, the response to those allegations will be due, again, under the old process in 90 days. If the institution has elected to process a case through an expedited hearing or a written submission hearing, which we'll talk about a little bit in a few minutes, you'll have 45 days to respond. But let's just say you're going through the regular process to an in-person hearing. You'll have 90 days to respond to the Notice of Allegations. You need to, in that response, establish a record. You need to have a detailed response. And you need to include in there your arguments on mitigation, aggravation, and standard factors. Now, one of the things that we're going to be doing, and we're advising everyone to do, based upon our conversations with at least one former member of the Committee on Infractions, that person disclosed to us that not all members of the Committee on Infractions reads every single document. They will rely upon the enforcement staff's documents. With that in mind, although I disagree with that, I think the hearing panel should look at all documents. If certain members of the hearing panel are only going to rely upon the enforcement staff's documents, you want to make sure that you contain an executive summary of your response. So you prepare a detailed response and you do a short executive summary, like a cheat sheet, a study guide, so that it is easier for a hearing panel member when they sit down and prepare for the hearing. They're going to look at all the enforcement documents, and then you have this executive summary that they can really digest quickly, and they can still rely upon your detailed response later. The second document that staff will prepare is a written reply, and that will be done 60 days after response to the notice of allegations. This is a new document to the enforcement process. It is an advocacy document. This is where the staff will be advocating its position. It's going to contain an analysis of the evidence. It's going to provide as a response or a reply to the institutions and involve individuals' responses to the notice of allegations. And so when you receive this document, you need to identify any inaccuracies, any errors that the staff has made in its summarization of the evidence, and any procedural issues that may be involved. And then if you identify those things, make sure that, again, you're actually revising your supplemental investigation plan, and you're addressing that by conducting more interviews, collecting more evidence, or doing other research. Now, the enforcement staff will have a pre-hearing conference, same as under the old process. That will be done now 60 days after the response to the notice of allegations. Again, as under the old process, is used to clarify the issues, answer any questions concerning the process, and making sure that that we're not there any allegations that need to be amended or withdrawn. Also, finally, the third document that staff will produce is called the Statement of the Case under Bylaw 1977-3. That will basically go into the chronology of the case, the allegations, the level of the case and the allegations, each party's positions on each issue, and any remaining issues. Now, the statement of the case may also be submitted along with the enforcement staff's reply, but it must be submitted prior to the infractions hearing. Now, again, similar to the written reply, you want to look at whether or not the staff has any type of inaccuracies, errors, or any procedural issues in the statement of the case. Strategy number 9 is pre-hearing filings. Before the infractions hearing, there are certain things you want to do before, including if there, again, you want to note at the beginning, I talked about if the staff has committed any procedural errors or the infractions panel has any procedural errors, you want to note that and submit that to the Committee on Infractions, or if the Committee on Infractions has appointed a hearing panel to hear the case, to the Chief Hearing Officer. And you want to do that, one, to create the record, and if you submit a pre-hearing filing on the procedural issues, you want to make sure that you resurrect that at the hearing itself and place it again. If you have any procedural issues, mention it again at the hearing on the record. That's a means to preserve your appellate rights. Also, there's a 30-day deadline. Under the old system, there was a 10-day deadline in which you had to submit documents that had to be considered by the Committee on Infractions. In the new process, is a 30-day deadline that if 30 days prior to your hearing, if you submit any additional information or documents, it must be considered by the hearing panel. Any documents submitted after the 30-day deadline, the hearing panel has the discretion to consider it at the hearing. So you will make sure that you docket that on your calendar. And as I mentioned before, you're going to have your supplemental investigation plan after you receive the notice of allegations. Well, that plan should be timed to where all your evidence should be collected, processed, analyzed, and a supplemental response, if you feel it's necessary, should be submitted to the hearing panel prior to that 30-day deadline. And if you collected any additional documents, conducted any additional interviews, that needs to be done before the 30-day deadline. I'll talk about in Strategy 10 about the mock hearing. We conduct mock hearings, and we recommend that you conduct mock hearings to prepare for the committee hearing. Well, that mock hearing provides several benefits, one of which is the mock hearing will allow you to know what are some of the weaknesses in your case. What are some of the evidence that your mock hearing panel has some problems with? If you conduct your mock hearing with sufficient time, that gives you a few weeks to be able to collect additional information so that you can shore up some of the weaknesses that you may have identified in your mock hearing. And that should be submitted before the 30-day deadline. Strategy number 10 is alternate processing methods. Under the old system, all the hearings were done in person. Under the new system, you can do an in-person hearing for level 1, level 2 cases, a telephone or video conference hearing for level 2 cases, and a written submission hearing for level 2 cases. The type of methods that you want to use to process your case will depend upon the fact of the case and whether or not all the parties agree to it or not. You want to have conversations internally about that at the very beginning. Don't wait until the very end of the case. You want to make sure that if you believe that this case is going to be best processed through summary disposition, you want to position the institution to be able to engage with the enforcer staff in a meaningful conversation that summary would be the best process, or any other method that you believe would be best to resolve the case. Depending upon the case, depending upon time and financial considerations, having an in-person hearing is going to be taking more time and more financial resources, versus having a written submission hearing is going to take the least amount of time and the least financial resources. If you decide to do an expedited or written hearing, you must petition the hearing panel within 14 days after the issuance of the notice of allegations. And so the hearing panel will then look at your request and decide whether or not an expedited or written hearing is sufficient for the case. The first type of processing method is summary disposition. That has not changed from the old process to the new process. It's for level 1, level 2 cases. All parties must agree. We believe this is really for the most straightforward cases. It's for cases that don't have a lot of novel or high-profile issues. And a school has the most influence on the penalties in this case because the institution proposes penalties, and then it will be up to the Committee on Infractions to adopt and or add additional penalties. And if the school has done sufficient research, then there will be less likelihood that the Committee on Infractions will add additional penalties. Though occasionally the committee does add additional penalties. The expedited hearing is the second type of hearing. It is for level 2 cases only. And an accelerated hearing occurs in 120 days versus 180 days of the old process. Again, if you want to select an expedited hearing, you do it by submitting a request 14 days after the notice of allegations. And then if the request is granted, you will have a hearing within 120 days, and the hearing panel has 30 days to review the expedited information done through the expedited hearing. It is done by telephone or video conference. However, the hearing panel has the discretion to do an in-person hearing if it feels it is appropriate to process the case. An expedited hearing, we believe, should be used for those you want a quick resolution. That you believe that it's best you want to be able to be present, either telephone or video conference, to answer questions from the hearing panel, to really emphasize certain points that you think can't come across in a written submission. And so we think that those will be better for those type of cases. The other type of case, or hearing, is a written submission hearing. And these are, again, for level 2 cases only. Again, if you want to do a written hearing submission, you submit a request 14 days after the notice of allegations. All parties must agree to do a written submission hearing. The difference between a written submission hearing and a summary disposition process is in a summary, all allegations must be agreed to. In a written submission hearing, allegations may be contested by the involved parties. We suggest that you use a written submission hearing when you have very strong facts in your favor and a case precedent is in your favor, and that you may have an involvement of an individual that's also cited, and that you think that the hearing panel may possibly level most of the severity of the penalties or the scrutiny toward that involved individual. So you do that for a situation where you have a rogue coach or a rogue booster, and you believe that your institution's case is so strong that the committee won't have a lot of questions, or they won't have a lot of information that they may need either in an in-person hearing or an expedited hearing using telephone or video conference. And the last strategy is hearing preparation and panels. We talked about doing mock hearings, and the type of mock hearings are going to be dependent upon the type of hearing that you're going to have. If you're going to do an in-person hearing, you want to have an in-person mock panel. If you're going to do a hearing by telephone or video conference, you want to do your mock hearing by video conference or telephone. You want to use the same type of technology or setup that you're going to use in the actual hearing. So you have a hearing panel, flesh out your case, get all the weaknesses, identify the weaknesses, shore up your presentation, and then you want to do a scouting report. You're going to receive the list of people on your hearing panel. You want to find out their background. What type of questions do they like to ask? Are they harder on coaches? Are they harder on compliance officers? Do they take little cheap shots at people during the hearing? Do they really pay attention during the hearing? Ask other institutions. Ask people that you know that have appeared before them to contain a really good scouting report. And then you need to look at the notice is going to contain the list of people that are going to be invited to the hearing. Are there any additional people that you feel that need to be at the hearing that can provide information that you feel the hearing panel may need? If you believe so, you need to get the hearing panel's permission. In a case that we had, there's a violation involving malfunction of the institution's technology. We brought the institution's IT director to the hearing to answer detailed questions if the committee had questions concerning the institution's technology. Also, you want to do thorough research on your case precedent. You want to be well-versed so that if there are any issues or arguments or questions along those lines in the hearing, especially along what level, should be a level 1, level 2, or mitigation or aggravation factors. You want to make sure that you're well-versed on all those areas so that you'll be able to articulate those arguments to the committee. Also, as I mentioned, you should have already made sure that all your documents you're going to rely upon are authentic, but you haven't done so. You need to do it during your hearing prep. And what we are using most recently is demonstrative aids. If you feel that an issue is complex or you just really want to hammer home just some basic elements of your case, create a demonstrative aid. In a recent case, we created a table where we had the list of allegations, our client's position, and we just listed in very brief terms all the evidence supporting our client's position. And the committee used that in its deliberations. Remember to look at the smallest detail. You'd be amazed. The Committee on Infractions will talk 30, 40 minutes on some of what you think is the smallest detail. And that's where having a mock panel is very helpful to really make sure that you're well prepared so you can anticipate any line of questions or issue that you may think is minor, but the committee members may actually, or hearing panel members may actually think is actually major and crucial to the consideration of the case. Again, during the hearing, you want to create the record by making sure if there are any procedure issues, get it on the record, making sure that all the facts are on the record, and so that you can have a really good appellate record if you need to appeal. And finally, if you feel that there are any procedure errors that occurred during the hearing, or the committee or the hearing panel asked questions that could not be answered during the hearing, or needs more information to resolve a certain issue, after the hearing, file a post-hearing submission and ask the committee to consider the post-hearing submission. But you need to do it as quickly as possible after the hearing. Now, we're running out of time, but there are duties and responsibilities that each member of an institution should have during the investigation. We have included a chart for those duties and responsibilities from the president on down to the human resources person in the webinar handout, and I direct you to look at that for just some of our suggestions, minimal things that each of those roles should do during an investigation in the enforcement case. We are out of time, but what I'm going to do is I'm going to take if there are any questions that were submitted during today's webinar, I'm going to compile those questions, provide responses, and send out all the questions and responses to everyone that registered for today's webinar. Before we conclude this session, a reminder to please complete an email, mail, or fax to us the evaluation form that was emailed to you yesterday. Thank you for your participation during our webinar. We look forward to seeing you during our next event. If you have any questions concerning an NCAA enforcement investigation, please do not hesitate to contact me or any of the firm's attorneys and professionals at area code 954-941-1844. Thanks again, and this concludes our session.